Thank you for joining us. My name is Amanda Olaogun. I am the Director of Communications with PBI Education, and today I'm joined with Frier Levitt's healthcare partners Todd Brower and Alex Keoskey for our webinar, Designing Impactful Interventions and Corrective Actions, More Than a Checkbox. So during today's interactive session, we're going to focus on practical real-world strategies to help you address concerns early, communicate effectively, and avoid unnecessary escalation to formal action. Our goal is to provide medical staff professionals, physicians, and healthcare leaders with actionable guidance to navigate complex situations with clarity and confidence. A little bit about Frier Levitt. They are a national law firm focused in healthcare and life sciences with offices in both New Jersey and New York. And you'll hear a little bit more about them when you hear about Todd and Alex's specific roles. As I mentioned, my name is Amanda Olaogun, Director of Communications with PBI Education. We provide continuing medical education courses to clinicians across the US and Canada, addressing and preventing unprofessional conduct. In my role, I regularly consult with licensing boards, employers, and healthcare systems regarding the most appropriate interventions for a specific situation, and also have an opportunity to work hands-on with the clinicians. Todd Brower is joining us today. He's a partner at Frier Levitt, where he represents hospitals, physicians, physician groups, home health care providers, and other healthcare organizations. His practice focuses on regulatory and corporate compliance, transactions, governance, licensing, and reimbursement matters. Before joining Frier Levitt, he served as Senior Vice President and General Counsel at St. Joseph Health System for more than 7 years. And before his in-house role, he spent over 3 decades in private practice. We also have Alex Keoskey, who is a partner at Frier Levitt's Life Science and Healthcare Practice Groups, where he focuses on healthcare litigation and complex regulatory compliance matters. He represents a broad range of clients across the healthcare industry, including physicians, pharmacies, hospitals, healthcare facilities, particularly in connection with regulatory investigations and enforcement actions. His extensive experience includes serving as Deputy Attorney General in New Jersey, prosecuting for the healthcare licensing boards, and he spent 20 years as the compliance officer for a large federally qualified health center in New Jersey. Additionally, I have the pleasure of working with Alex as a faculty member with PBI Education, where he teaches our professionalism and ethics courses. So just a few housekeeping notes as we get started. This webinar is being recorded, so you'll receive a link afterwards with access to the on-demand replay that you can rewatch or share with colleagues. Please note that while Todd and Alex are attorneys, today's discussion is for informational purposes and it should not be construed as legal advice. We're going to be covering these topics at a high level, but we will share our contact information at the end of the webinar should you want to discuss any of these with us further, any specific situations. If you have questions during the webinar, there is a Q&A feature. We'll address as many questions as we can at the end, and then we'll follow up with you if we're unable to get to your question. We do have a few learning objectives today. By the conclusion of the webinar, you should be able to understand the implications of formal corrective action on both the physician as well as the organization, identify various strategies for early intervention to proactively address conduct and performance concerns, and understand the role of empathy and communication to implement these different strategies. Wonderful. We're done with our housekeeping, so jumping into our content. When we talk about early interventions and behavior for physicians, the types of behaviors that we're talking about can really range, starting with quality of care, clinical performance, all the way through impairment, as well as any kind of boundary violations. Those can be with fellow staff members, fellow clinicians, as well as with patients. And then we have a large gray area of unprofessional conduct that really falls into this conduct that requires intervention. And that can range from inappropriate communication and humor, communication that's disruptive, inappropriate accessing of EMR records or not completing records in a timely fashion, as well as bullying and harassing conduct. And the reason we're talking about this today and the risk is there's a large risk of mishandling interventions. And overwhelmingly, that risk comes with an impact on patient safety, which is overarchingly our main goal is protecting patients and providing safe care. But there's a lot of other risks, both to the physician as well as the organization, that can trickle down when these interventions are not handled promptly or properly. Those can include legal aspects in terms of lawsuits. There can be financial implications, both again to the physician as well as the organization. It can impact team and staff morale, both for clinical as well as administrative team members, and ultimately end up in losing a valuable part of your medical staff. So that's really our goal for today, is kind of understanding how we can minimize these risks by addressing issues early and having impactful interventions. With that, I'm going to hand it over to Alex.
All right. Thank you, Amanda, very much. Good to work with you again. And that's a good introduction to give us a good vantage point on some of these slides. And the first thing we really need to recognize is that all corrective actions are not necessarily considered adverse actions. Adverse actions are disciplinary and most times require reporting to a regulatory authority. And most important, some type of due process and appeal mechanism for the medical staff member, the physician. As an example, an FPPE, a focused professional practice evaluation, is an example of a non-disciplinary corrective action, which entails a kind of monitoring for the physician based on whatever issue arose, whatever corrective action needs to be taken. And that would be considered a routine corrective action, which would not be reportable to any regulatory agency, would not necessarily involve any kind of appeal by the physician or any type of due process. Adverse actions, since most are reportable, are more concerning. Obviously, they have larger ramifications. So it's very important that from the perspective of both the hospital and the physician, that for the physician, the bylaws are read and understood. And from the perspective of the hospital, that the bylaw procedures are followed to the letter. That's really important. The bylaws will be the only source of understanding the timeline for the adverse action procedure, the committees that may be involved, the appeal rights of the physician, including a fair hearing for the physician or medical staff member, and then any appeal beyond that. So the bylaws really spell out the due process afforded to the physician that has to be provided by the hospital. The process is very similar in all hospitals across the country. What due process is afforded to the physician is really going to depend on the severity of the action involved, the nature of the action. And for example, we see in the first bullet point, a summary suspension is mentioned. A summary suspension is more commonly referred to in the bylaws as a precautionary suspension. And in order for the hospital or the health institution to invoke this adverse action, a certain threshold has to be met. And most bylaws will use terminology, almost all of them will use a terminology which indicates that a failure of the hospital to take such action would result in imminent danger to the health and safety of any individual. That's usually the threshold for any kind of summary or precautionary suspension. But a summary suspension can also occur automatically if another regulatory authority, such as a licensing board or a criminal prosecutorial authority, invokes a severe action against a medical staff member. If there's an arrest for a really significant criminal action, or if the physician has a suspension of his licensure, the hospital would take action automatically accordingly. And the bylaws, again, will spell out the standards and the procedure for this type of action, and more importantly, the grounds for appealing these type of actions, which are really important for the physician and the hospital. It's important to note that there's really no particular category of behavior which will automatically result in a suspension, whether it involves, as Amanda mentioned before, quality of care issues, a misconduct issue, an impairment issue, or even a civility or communication issue. It's really the severity of the issues, of the issue itself in the eyes of the hospital, and also if there's a pattern involved. So a suspension can occur for any of those issues, but it really depends on the severity. Some of these issues could be relatively minor, some of the occurrences, and can result only in an FPP or a warning. It really depends on several things. Number one, again, pattern. Whether it be misconduct, quality of care, anything like that, that the hospital is more likely and should be more likely to take severe action if the doctor has received a warning about this type of behavior previously, and there is a pattern of this type of behavior. So certainly the number of incidents of the same type which occurred is going to make a difference. And it happens a lot with behavioral or disruptive issues, which are really have been the subject of a lot of adverse actions by institutions now. Most bylaws have a provision which allows for disciplinary action if the physicians demonstrate a behavior that's considered, usually the term is disruptive, and affects patient care. If this type of behavior is ongoing and results in different complaints by different individuals across the spectrum in the hospital, from ancillary staff to colleagues, some action should be taken by the hospital. And the same should be said for quality of care issues, misconduct, and impairment. And mentioning an impairment, and I know that Amanda mentioned this, and these unfortunate situations where a physician may be found to have a drug or alcohol problem or psychological impairment or an impairment related to age. A type of action which would depend on the severity of the occurrence and the severity of the condition, obviously. The difference, for example, between an anesthesiologist who might be stealing medication and ingesting it on the premises during work hours, during surgeries, as opposed to a nurse possibly detecting alcohol in a physician's breath during the day while he's on rounds. Obviously, there's different levels of conduct that require different levels of discipline and are going to dictate whether the discipline is severe and requires reporting, or whether there will be a warning and a more step-by-step action. So the results are going to vary, and this is where bylaws are important, because the bylaws must spell out the rights of these physicians that they have in these circumstances, and also the procedure that the hospital will use through the committees and through the fair hearing. So that takes us to our next slide of when an action gets reported to either the state medical board or the National Practitioner Data Bank. In most states in this country, if there is a precautionary suspension of a member of the medical staff, it will get reported to the licensing board pursuant to state law. However, that suspension will not get reported to the National Practitioner Data Bank, the larger clearinghouse run by the Federal Department of Health, unless that suspension or any adverse action that's invoked against the physician lasts more than 30 days. So 30 days is an important number to remember. That's the cutoff point. And to be clear, that would be any restriction or condition on the physician's medical staff privileges which exceeds a 30-day span. And after that 30-day point, the hospital is required by law to report the adverse action to the National Practitioner Data Bank. And that would be a type of condition, a severe enough condition or restriction that conditions or restrictions the medical staff privileges that the practitioner had prior to the discipline. That would be reported if it goes beyond 30 days. So obviously, between the hospital counsel and counsel for the physician, the goal is always to try to resolve these type of matters before that 30-day cutoff to avoid the reporting to the data bank, if possible. And I have to stress, if possible, because remember, a report to the data bank is permanent. But if the severity of the occurrence is bad enough, almost inexorably, that 30-day period is going to be exceeded. For example, a severe type of behavioral issue by a doctor, or really terrible misconduct, sexual harassment, things of that nature, threats, likely the 30-day suspension is going to go beyond, or the suspension is going to go beyond 30 days. And there also might be some type of prophylactic measure, a course that the doctor or is told to take that will last beyond 30 days. So simply keeping it under 30 days is just not possible. So again, a report to the data bank is permanent, so it's really, really important for any authorized members of hospital medical staff to report only when reporting is required, but also to make absolutely sure that they report when it is required. This is where hospital counsel should be notified and help ensure that reporting is accurate, complete, and necessary. Again, we have to go back to the nature of the offense and the corrective action that's being invoked. If it's a FPPE, that would not be reported to the licensing board or regulatory agency, including the data bank. If it's a summary of precautionary suspension, it would be reported to the licensing board. Then that licensing board would likely follow up with the physician to get their version of events. If it's summary suspension or restriction or condition on licensure that lasts more than 30 days, it would be reported to the data bank. So I guess it's a good time to go through some samples here of particular instances in vignettes. I'll read it quickly. Here's one sample issue. Dr. Smith is notorious for being difficult to work with and engaging in abusive conduct in the operating room. He screams at technicians, nurses, and even other physicians when they are not doing what he asks or expects. He's also known for making demeaning sexual comments toward female nurses when they do not perform up to his standards. Before commencement of a recent surgery, Nurse Jones called a timeout to confirm that they had the right patient, they were performing the right procedure, and were operating on the correct limb. Dr. Smith, who had already had performed 5 cases and had 5 more scheduled, screamed, "Okay, honey, we don't have time for this," fill in the blank with a curse word, nonsense, and ordered the procedure to commence. So, question is, what would be the appropriate intervention in this case, and should that intervention be reported? These are important considerations for hospitals because, again, I do have to stress this. Hospitals must report adverse actions to the data bank, complete and thorough reporting to the data bank if it is warranted. If they don't report, they can lose immunity, and I can explain that in a little bit. So should this person have some type of intervention that is a little more severe than normal? Well, let's look. Do we have the pattern we spoke about before? It says is notorious for being difficult to work with. He's known for making demanding sexual comments. So you have a pattern and you have some severe conduct, which is sexual harassment and a lot of other legal causes of action that could really put the hospital in jeopardy if there's a lawsuit. So probably the hospital would be wise to invoke a precautionary suspension against Dr. Smith in this instance. He doesn't seem to have any kind of contrition or regret about what he's done, and he seems to be a very volatile individual. The type of intervention should probably be severe, and if it's required that this doctor take a course in civility or communication or some type of course to ensure that he does not have a larger impairment, that is probably going to last 30 days, which means that 30-day span of time I mentioned before will be exceeded, and he will probably be reported to the data bank. It means the precautionary suspension, if it's invoked by the hospital, it is always up to the hospital, would be reported to the licensing board. The 30-day span gets exceeded for the suspension, he'll be reported to the data bank. So that's that particular instance again, because the severity of the nature of the occurrence and the pattern here. Let's go on to the next one, Amanda. A little more mild here. Let's read this one carefully. Nurse Jones filed a complaint of harassment and disruptive conduct against Dr. Smith with the hospital HR department, as well as the president of the medical staff, citing repeated instances where she had been bullied or had witnessed others being abused by Dr. Smith. When approached by administration, Dr. Smith apologized and said he realized he shouldn't have lost his temper, but he's a perfectionist. He insisted that his behavior is only the result of the incompetence of others and that he only has the best interests of the patient in mind. I know many of you have seen or experienced doctors like this before. It's quite common. What would be an appropriate intervention? Should that intervention be reported? All right. So first of all, is this a pattern? It's not really clear, but it says citing repeated instances where she'd been bullied and witnessed. So there's a pattern. So that certainly warrants some type of corrective action and probably discipline. But should he be suspended? Look at it again. Again, it's always up to the hospital. He apologized. He said he realized his behavior was bad. So that's hopeful. The fact that you should not have any kind of corrective action or a corrective action is not going to be successful unless the physician themselves realizes what they're doing wrong and is open to rehabilitation, right? Otherwise, it's a waste of time. But is the suspension warranted? Probably not. Probably sending this individual to some type of course that can help him, guide him through civility and communication issues and make him a better practitioner for that reason. It's up to them. Maybe an FPPE after that's period of suspension is over, but hopefully trying to avoid a report to the data bank. So that's an issue. And again, you have to look at individual cases, and a hospital has to do that kind of creative thinking is what is warranted here and what must be reported, because there's obviously, as Amanda said, a risk management issue here. So on that note, we can go to the next slide. An impact on career credentials, reputation, and mental health. There's an impact always for any reporting of this nature for both the doctor and the hospital. For the doctor, it's obvious. Going forward, if there's a permanent report to the data bank, any type of credentialing that the doctor undergoes, whether it's license renewal, applying for a specialty board certification, application for medical staff privileges at a hospital, accreditations, certifications, anything. The first thing that credentialing agency is going to do is look to the data bank and see if this doctor's been reported. and that permanent report is going to be there. That can seriously hinder a practitioner's ability to get other additional work, even locums, when that data bank report is there. It can certainly affect mental health, can certainly affect a career. For the hospital, the financial implications of not reporting, they'll lose their immunity. The way that the data bank was created was by a statute called the Healthcare Quality Improvement Act. At the same time, the Congress created this data bank as a clearinghouse for reporting. It also created immunity for hospitals and others to ensure that they cannot successfully get sued if they provide a complete report when appropriate and an accurate report. So for the hospital, there's a lot of ramifications as well. The hospital also has to ensure that they report when they're supposed to report, that that report is truthful and accurate, and that they file all the, or I should say, follow all the steps in the bylaws to absolutely ensure that they're doing the right thing. And with that note, I want to turn over to Todd. But Todd, first ask you if you have any comments or any follow-up on what I've just presented.
Thanks, Alex. Yeah, actually, the one comment I would just make as you're talking about all of these various investigations and corrective actions, there's been a movement, as we all know, towards physicians being employed by hospitals and healthcare systems. That wasn't the case 20 years ago. Everybody or more, almost all the physicians were volunteer members of the medical staff. Now you'll have healthcare systems where actually the majority of the physicians end up being direct employees of the hospital or perhaps employees of a captive physician group set up because of the corporate practice of medicine. In any event, now you have the hospital system's HR department involved in this. And it's important because you need to have communication and coordination between the medical staff and the HR department, because the last thing in the world you want are two separate independent investigations going on that may come to two different results or recommendations. So you see one deferring to the other, which is fine, or they do it in conjunction. But the important thing to remember is that it needs to be coordinated. What we want to do now is going to spend a few minutes on this slide talking about the various tools available for proactive and meaningful interventions when problems are identified, whether they're of a clinical nature or a behavioral related matter. This has historically been a challenge for hospitals. If you look at medical staff bylaws, typically they have a process where a problem is identified, it's investigated, and then it jumps to summary suspension or a recommendation for revocation of privileges, which I kind of look at as the nuclear options. And the problem is that triggers, as Alex was talking about, these fair hearings, which everyone has in order to get the immunity from the Healthcare Quality Improvement Act, or as in New Jersey, as in other states, there's a ton of case law that sets forth the requirements for the protections of the physicians that a hospital has to follow in these fair hearings. They're very costly to both the hospital and the physician, and blame it on the lawyers. They're very involved. They're very intense. I can guarantee you, if you talk to a physician who ever served on a hearing panel, I'm pretty sure the first thing they'll say to you is, "I'll never do that again." Nobody wants to do it. So, what's missing in a lot of bylaws is kind of, a collegial intervention that can well address the problems adequately, protect the hospital, improve the care rendered by the physician without having to trigger, the nuclear options. Probably the model most people have heard about and are familiar with is the Vanderbilt model, which provides progressive steps of intervention to help physicians address issues and hopefully avoid the nuclear options. Many hospitals have moved already to some form of this model, and probably more hospitals should. This model has been subject, there's a ton of literature out there, it's been peer reviewed, and it's been proven to be very, very effective. And it also can go hand in hand with high reliability organization programs that many hospitals have adopted as well. If you know about the Vanderbilt model, the familiar graphic is a pyramid. The base of the pyramid is the vast majority of your providers. have no issues, or maybe the one issue comes about, but essentially it's dealt with at the moment, and there's no further issues. The next step up the perimeter is when a problem's been identified, investigated, and confirmed that it merits attention. If it's seriously egregious, you may well have to jump to a summary suspension. That you don't not do that if it's actually called for. However, if it can be addressed collegially with an intervention and discussion, that's the first step. Some hospitals and medical staffs refer to it as, a cup of joe, a cup of coffee, sitting down, discussing the issue with the physician, identifying the issue, and suggesting, remedies and ways to change practice. I'm never a fan of one-on-ones discussions, because you can always end up with a he said, she said situation. So I always think those discussions are probably good with two people. One, it's going to let that physician know that it's actually a serious issue and being taken seriously. And second, there's a witness as to what was actually said and perhaps agreed to. I'm not a big fan of more than two people in that initial collegial intervention, because once you get to three or more people, the physician may feel they're under attack. He or she might get defensive, and so I think it can be counterproductive. Oftentimes, this is the end of it. The issue's addressed and you move on. However, if it appears to be an apparent pattern, then you move up to the next step in the pyramid. Here you may employ a small committee. Needs to be determined by the hospital what's appropriate, because it's not one size fits all. But basically, you have a committee to address the issue with the practitioner. I worked with one hospital. I have to be honest, I can't remember the official name of the committee. It was an ad hoc committee, but we always affectionately referred to it as the bad boy committee, because it was always males that were coming up, unfortunately, for issues. But the committee would meet. It would be 4 or 5 individuals, have the CMO, but the rest of the committee was still peers, not administration, certainly not lawyers, not risk management. It was a peer-to-peer collegial intervention, and they were very effective. In fact, in that situation, although it was an ad hoc committee, eventually it ended up being a permanent committee, standing committee. And you also at this stage may invoke a focused professional practice evaluation, FPPE. We'll talk a little bit more about later. But if the pattern persists, now you're moving up further in the pyramid. And here you may be bringing the individual in to meet with a full med exec, or maybe the credentials committee, or somebody that's really going to drive home the point that this is a serious issue. And this is also where it's referred to as implementing a guided intervention. For example, certainly an FPPE is appropriate here, but also performance improvement plans. Both I'm going to address again in a few minutes. Ultimately, if there's no change, you're at the top of the pyramid, the last step, and there you're at the nuclear options. This is where you summary suspension, or perhaps a request to terminate privileges. It's important to note, though, that the studies that have been done regarding this model have shown that the percentage of physicians who ultimately reach the top of the pyramid is almost negligible. So it's very, very effective. Again, the tools that can be used along the way at various stages here include the FPPE. Now, as you know, all physicians are under FPPE. It's actually a Joint Commission requirement when they first come on staff, okay? It's just an evaluation because you don't have a history with them. But it can be triggered later on when a quality of care, typically a quality of care concern, is raised. On its face, as Alex was talking about, it's non-punitive. It's intended to help the physician. Typically involves review of medical records, observation, meetings with the physician, maybe CME requirements, but it's not a punitive action. Now, as Alex mentioned, an FPPE by itself is not a reportable event, but you do have to be careful how you structure the FPPE. If it includes restrictions, for example, you can't schedule a surgery without getting it reviewed and approved in advance, or you can't perform the surgery without a particular physician being there, this can be interpreted as a restriction on privileges and may have turned that FPPE into a reportable event. Likewise, you have to understand, and physicians need to know this, that if they're subject to an FPPE and they resign during it, that too can sometimes be interpreted as resignation under investigation, because it's technically an investigation, and that may turn into a reportable event as well. Performance improvement plans can be very effective also. Again, on their face, they're not punitive unless the physician's non-compliant. An effective performance improvement plan is going to be very specific to the issue. It's going to have measurable and realistic achievable goals. It's going to have a defined time frame in which those goals need to be met or achieved. And it clearly sets forth the consequences for not meeting those goals or objectives. And I think what's also most important for an effective performance improvement plan is, in fact, that the hospital, the medical staff, provides the necessary resources for a practitioner to succeed at it. Good example, recently involved with, it's kind of the classic example, medical record issue. All hospitals, all physicians struggle with this, but we had a situation where the physician is an outlier. He's so outside the realm of normal range of outstanding medical records. They tried to deal with it. Finally, they had a meeting with him, and they essentially came up with a performance improvement plan that required that he needed to update, get the outstanding medical records by X date. He could not allow medical records to go beyond Y, et cetera. And it clearly just said the consequences were, if he doesn't meet these deadlines, it would begin first with a certain number of days suspension. The second time would be longer suspension, and the third time would be revocation of privileges. Very clear and very concise and very measurable, achievable goals. The other thing was, as in that case, the CMO and the medical staff were very good at reaching out to the doctor and saying, what resources do you need? We consider you a valuable member of the medical staff. We want you to achieve these goals. We want you to succeed. If you got a tech issue, let us know. We'll get it taken care of. If you have other issues that we could provide resources to help you, that's important that we do that too. Now, also, obviously, as part of a performance improvement plan, you can incorporate other tools, such as the CME, whether it's for clinical or for behavioral type issues. And these are the kind of courses that PBI does. Both Amanda and Alex are actively involved in presenting these courses that can really help physicians develop the skills they need. Again, it's non-punitive. It's a very effective way of improving the skills of a physician. As part of it also, you can have mentoring and coaching. Of course, it's obvious that it's important to have the right individual who's taking the right approach with it. But those are all tools you can use in terms of these interventions. Here's an issue that people should, kind of focus on too. Who pays for all this? I know some hospitals take the position that it's the physician with the problem, they've got to pay for it, and I understand that. But I think you have to look at what's being asked of the physician. For example, if you're sending the physician to a remote location that's going to require them to fly, hotel expenses, maybe you have to go more than once back and forth. That's going to be very expensive for the physician, obviously. They're not working while that's happening, so they're not generating revenue. It's different than if you say, okay, we've got some courses you need to do online or going someplace local. It's not a big imposition. I think you have to look at it and take it into consideration. Quite frankly, if you want to invest as a hospital or medical staff in the success of this physician, you might want to consider covering some of the costs, splitting the costs, maybe taking all the costs. It depends on the given situation. But who pays for it, I think, is something you really need to consider. We also have, like in New Jersey, and Alex mentioned it, and I'll just briefly mention again, the Physician Assistance Program, the PAP. For people who have perhaps an addiction problem, but also behavioral health issues. They deal with anger management and other disruptive behavior. Very effective in that it not only helps the physician, provides protection for the hospital because you're taking action, but it is confidential and is not used by the Board of Medical Examiners to go after the physician. And that's one of the most important aspects of it, to protect the physicians. And because we're not out to destroy their career, we're out to help them. There's a right way and wrong way of doing all this. When it's really for these interventions are for restoration and improved skills, and it's not punitive, that's good. But once it's viewed and becomes punitive, they can be very ineffective. And if they include restrictions, as I mentioned before, on privileges in order to fulfill, for example, a improvement plan, that can result in reportable events, which is what we're trying to avoid if we can, if it's appropriate. One last thing I just want to mention before I turn this back to Amanda, and it's something Amanda will probably touch upon, and I think it's also something that's dealt with in any number of the PBI programs, and that is cultural awareness. Over the years, and I've been doing this kind of a long time, and I've seen physicians, problem physicians, disruptive physicians in particular, not treated equally. And what I mean by that is often, this is a result of unconscious bias that we're all afflicted with. I see this primarily with regard to behavioral issues where physicians of certain cultures or ethnic groups are brought up more often than others, even when the same issues are the same across ethnic and seen across the same ethnic and cultural lines. You need to be sensitive to this. Are some of the concerns truly a result of ethnic or cultural issues that we need to understand better? Perhaps language barriers and the way the person comes off. If so, all the more reason why these intervention steps are so important before you jump to the nuclear options of summary suspension or revocation of privileges. Of course, cultural or ethnic differences are not an excuse for inappropriate behavior. However, you need to make sure that similar behavior by physicians of different cultures and ethnicity are treated the same. And I think you have to be aware of that. At this point, I'm going to turn it back over to Amanda.
Wonderful. Thank you, Todd. I'm going to transition and talk about, as we're going through those interventions, what tools you can use to set the physicians up for success and to set the organization up for success in those situations. So we're going to begin talking about empathy, and most people are familiar with the term empathy, but just for the sake of our discussion, I wanted to cover what definition we're going to be functioning from today, which is putting yourself in the perspective and emotions of the other person. I want to call specific differences to sympathy, which is looking at it from our perspective, but also a concept we talk about a lot in healthcare of compassion, which is taking that empathy a step further and putting action behind it to actually alleviate someone's misfortune or situation. That's not what we're talking about here. We're not going to this as far as this type of compassion, but I want to look at empathy and how we can use that when we're putting together these different interventions. So we're going to use this example that we actually use in several of our courses that we refer to as parallax. So this comes from the science and astronomy, where the appearance of an object differs according to your position to that object. So if Alex and I are in different locations compared to an object, the appearance might differ to each of us. And that's really represented in this cartoon depiction of an ancient folktale with this elephant, where you'll notice people surrounding the elephant and they're all blindfolded. So what their perception is, what they can feel and touch in front of them. And that's going to differ based on where they're located. Are they on the side of the elephant? Does it feel like they're touching a wall? Not necessarily an animal. Are they holding onto the tail so they think it's a rope? And what this really calls attention to is the unique vantage point and perspective that each person is coming at from a different situation. very similar to this of where your location is around the elephant, your different role and relational position within an organization, within the healthcare system can really impact the view of how you see a situation or how we're looking at something. And when we're looking at addressing conduct that an intervention, it might be necessary, or we need to start that cup of coffee conversation with a physician, we really want to begin by relocating to ourselves to their location, just mentally, to their location to understand what else is going on. How are they viewing this situation, and what can we grasp by looking at this from their perspective and their location? And so what we get out of kind of changing our perspective on this is it offers us insight. So you can gain additional understanding rather than just looking at the facts of a case and the situation going on. It really allows you to gain understanding of what is behind all this, what is causing it, and what additional is going on for that physician. Are there other things that are contributing to their behavior? We've talked a lot about potential situations with impairment today. And is that something that's contributing? Maybe they're being what we would call disruptive in the operating room. Is the disruptive behavior the problem, or is there an impairment that's causing the disruptive behavior? So when we approach it with curiosity and empathy, we're able to really look at a situation and say, what's the bigger picture here? What's going on for this physician? Oftentimes what we've seen with people coming to our courses, there can be underlying background of maybe their life experience or other places that they've practiced that are impacting how they interact in the workplace or with patients, with their colleagues. This comes up often, as Todd was talking about, with cultural differences. And maybe if someone throughout their entire career has been targeted, treated differently, had situations at other hospitals where there's constantly friction and turmoil based on cultural differences, that can really impact what they bring to their current institution. So we're going to use empathy as a tool to gather insight and really determine the most impactful intervention. When we look at the list of toolkits that Todd discussed with us, we can really see those are going to be appropriate in different situations for different people, and having this additional insight helps us determine which of those is most appropriate. Additionally, we can use this empathy that we're practicing as a communication tool when we're having those cup of coffee conversations, whether your role is as the CMO or another clinician having those conversations, or potentially as a member, one of the MSPs, medical staff professionals, interacting with them, really allowing them time to share. When you're being curious, giving them time to provide you with additional information, making sure that you're attentive, that's going to help build trust with them. And when they can trust that they're being heard, it's going to help them follow the PIP or whatever you are asking from them. They're going to be able to be more compliant with that. Just some tips for when you're listening, reflecting back, acknowledging what you're understanding, repeating that back to them to ensure that you're understanding them correctly, asking them to help you understand the insight and background behind it. And while you might not agree with their perspective, it's helpful to acknowledge that their perspective is truth for them, and that's where they're coming from. And even if it's not something that you believe is correct or accurate, you can at least acknowledge that perspective as a standing point for where you can move forward. And so when we look at this, something we experience a lot as a provider of remedial education is how different organizations and how they prepare a physician to attend a course really impacts the physician's success in our programs and participating. Part of our title for this webinar was that this is more than a checkbox. And while we talked through the different requirements for reporting and kind of checking off all the boxes from a compliance standpoint, it is important to remember this is a process. Behavior change requires a process, and it's not something that happens overnight. You don't send a physician to a course and they come back on Monday completely changed and perfect and no follow-up is ever needed again. It would be wonderful if it was that way. Unfortunately, it's a process to implement and maintain change in behavior. So just keeping that in mind as you're going through and providing the space for that process to occur as you're going through the process. We spoke a little bit about the beginning about preventing the escalation of these issues, that early intervention, the cup of coffee conversation really is ideal, allowing you to correct it sooner. And the sooner you can have that kind of course correction, just like if you're driving down a road and you take a wrong turn, the sooner you know you're on the wrong road, the faster you get back to where you need to be. So the sooner you can help these physicians course correct, get them the tools they need, the faster they can be back on the career path to take care of patients better. Part of what Alex talked about as well as Todd is having your policies, processes, bylaws in place. This is really helpful to make sure that it's being consistently shared with everyone across the board, but also to make sure that you are compliant with what the requirements are. Alex, Todd, do you guys have anything to add with policies, bylaws, and how that helps the organization set the physicians up for success?
I'll start just because I want to couple together a really great point that Todd made about not just cultural competency, but avoiding any type of appearance of discrimination against any particular group, ethnic, gender, any group among your hospital staff or ancillary staff. And also your last square there, Amanda, which I think is important, consistent and fair enforcement of policy. From both the physician and the hospital perspective, it's absolutely essential that any policies under the bylaws, any procedures under the bylaws, the fair hearing, the investigation is applied consistently and fairly for each and every individual staff member, exactly the same. Nobody should be left out with regard to following all the steps in that procedure and allowing for the process that both you and Todd had described. It's really essential for the physician as a matter of fundamental fairness, but more than that, for the hospital to avoid liability. I know when Todd has represented hospitals, I've represented physicians. We've both done a lot of this work. Any action that's brought against a hospital or causes of action can be varied in these type of circumstances. It could be from some of these nurses or staff who feel they've been victimized by some of these doctors we've illustrated here, but there's been no recompense. There's been nothing coming from the hospital that illustrates that they took it seriously or they investigated or they took action. And that's one type of action be brought by staff, but another action can be brought by the targeted physician themselves is that the process wasn't fair to me. They didn't take all the steps that they normally take, and I'll prove it to you. I'll look at all these other doctors who have been disciplined back in May and back in July of last year, and look at all the due process they got that I didn't get. And maybe Todd has some comments about that too, because I know he's seen that from the inside from hospitals.
Yeah, it's interesting if you go back to either one of the hypotheticals, Alex, you used. It's very interesting because talking about being consistent and fair. In both those instances, you made the good point. It's a pattern, and therefore it may rise to the level where a summary suspension or serious action should be taken. But here's the challenge hospitals have, and I've sat through meetings like this all the time. You have a physician that's engaged in behavior like that, and someone says, you know what, he does it all the time. He's been doing it for years. And then you sit there and you go, okay, what did we do about it? And it may very well be they never did anything about it. And so, now you have the situation where if you're going to be fair, it may not be jumping right to a summary suspension per se. You may actually be having to do a collegial intervention because you got to give the person an opportunity if you didn't address it before. One other just quick point I would make with regard to policies and processes in place, and I'm probably stating the obvious. These collegial interventions, which are so good and effective and proven effective, shouldn't go in the bylaws. Bylaws are such a cumbersome document and process to amend, and this is evolving. I think, even as good as the Vanderbilt model has been proven to date, there's going to be new ways of approaching this. There's going to be new, ways of doing it, and put them in policies because policies can be changed. Policies can be adapted a lot easier than bylaws. I see people try to define way too much in their medical staff bylaws, and it becomes difficult to change.
That's a very good point. Another component of bylaws we often see, Todd, is a code of conduct for the medical staff. What's expected of them with regard to things like civility of communication, honesty, conduct, things of that nature, and reporting. So those are all really good points. Amanda, do you want to follow up with that? Because you obviously have your frame of reference as well as a as from PBI and the types of many various different types of cases we get, and type of individuals and the types of adverse actions that have been invoked against them.
Um, Not specifically on this slide, but that kind of takes me to my final slide, which is really reviewing the communication of the process and what we've learned as an educational provider with that. And a lot of this is things that we've kind of talked about throughout the webinar, and so they should be really reminders more than new information, but really having a constructive tone, not having a punitive nature to how you're communicating with these providers. They can tell when something's punitive and when it's we're doing this and we're making you pay for it because we want you to feel the pain of this. Or is it, hey, we want this because we want you to grow and be a better physician and work better with the staff and be able to treat patients more safely? What is the tone you're using when you're providing these? We've talked about leading with empathy. And when you do that, one of the things we've really seen to be very successful, and this, I really like the example with Dr. Smith we talked about earlier, is aligning goals. So in the case you talked about, Alex, Dr. Smith brought up that his goal is keeping the patient safe, making sure the patients have the best care possible. And that's wonderful. He says that because then whoever, whether it's the MSP, the CMO talking to him can say, wonderful, that's our goal too. We're on the same page. We have the same goal. We can step forward together and not combating against each other. This isn't a head-to-head issue. This is a how do we move forward down the road together. So we've seen that be really successful when that's the approach that different institutions take with their physicians. Be specific is something that Todd talked about when he said putting together the PIPs and other expectations for them, making sure you're outlining deadlines, what it means for them to be compliant, who their point of contact is, what the consequences are, who's paying for this, who's responsible for different aspects of it. That's going to be really important to be specific with them throughout that process. And then noticing as well any accommodations they need to be successful. So the most disheartening thing that I can see when I'm working with a participant coming to a course is when we're looking at the performance improvement plan that was put together for them to come to a course, and it's impossible. It's the time frame of when they are required to take a course isn't actually feasible, so they're really being set up for failure. So making sure accommodations are in place for them to complete that success, whether that's do they have call coverage so that they're not on call during their course weekend? Do they have availability to take time to actually complete the course? Are you giving them a reasonable time frame? Are there courses that exist that they can take within the next 4 weeks? So really finding those options for them is going to be important, and just making sure that there's mechanisms there for accountability to help them facilitate change that's lasting. That's really our goal here, is we want impactful change moving forward. Do you have anything, Alex or Todd, to add to that?
We have a question. Before I get to it, I wanted to make comment on what you just said, Amanda. I'm glad you brought up those points. And I wanted to actually direct it to Todd first. And that is, you talked about tone. It's really important, not just for the interface between the hospital medical staff and the doctor, but between counsel for the hospital and the doctor's counsel, and when that intervention needs to be met. And Todd, I know, has a good reference point on this, because actually Todd and I, before we worked together in this firm, I was representing a physician, he was representing a hospital who had an adverse action against a physician, and we managed to resolve it because we were civil to each other. We understood each other's role, and our tone was just where it should be measured. Sometimes you'll have instances where there's a lot of acrimony between the hospital medical staff and the doctor, just for whatever reason, pattern or otherwise, and getting counsel involved early to kind of tone it down as the saucer for the teacup is very helpful. I'd like Todd to comment about that, but I just before you do, Todd, you can answer this question that came up from one of the participants. I'll read it. Do you feel that early non-punitive intervention combined with the hospital providing resources, paying for a course, coach, etc., affords the facility some degree of protection in the event the physician sues the facility? Todd, that's a good one.
Yeah, I think it can. I mean, this is a difficult issue because you don't want the cost of what you're asking the physician to do to appear totally punitive. In other words, it's going to wipe them out. It's going to be very difficult for them to comply. So if they ultimately sue the hospital, that obviously is going to be part of that claim. Where you draw the line, I don't know. You know, I have seen situations where basically these kind of things, as costs are split. But, you know, again, it'll have to be decided on a case by case basis. So I think, you know, and, you know, going to your other point, you know, it's like you can't pick your family members. You can't pick the attorney on the other side. But
So
you
true.
really hit the nail on the head. There is nothing worse. And I've been on all three. I've been where I've represented the individual, I've represented a medical staff separate from the hospital, and I've represented the hospital. Having a knowledgeable, good, and reasonable attorney as the adverse party makes all the difference in the world. The attorneys, one, who have no understanding of what the whole medical staff process is, or a hospital privileging and credentialing, is a mistake. That becomes a disaster. And then the attorney who has to bang the table and scream and shout and threaten ends up making, you know, collegial interventions almost impossible, and then makes a hearing, you know, a month-long affair at high cost to everyone involved. So you're absolutely right. You really need good, knowledgeable, experienced attorneys on both sides. So that's the only way it's going to work.
No, I agree, Todd. I liked your answer to the question as well. I would agree with you. It really depends on the circumstance of whether that affords the hospital any protection. One thing's for sure, and having handled a lot of employment cases and tried a lot of employment cases, the first thing a plaintiff attorney suing a hospital or any facility looks for is, was my client treated differently than other people, and for what reason? Because why? They don't just want to bring a claim, you treated my client unfairly, but you discriminate against my client because of their race or sex or something else, or you harassed my client in some way and were acrimonious toward my client in a way that you weren't with other practitioners, and we'll bring those other practitioners in here to prove it. So I think, yes, the early intervention, I don't necessarily know if the hospital has to provide the resources. I know hospitals generally will tell the physician, we're invoking this particular remedy. Here's a course you need to take. We think you need to take it. We can help you out, but you have to pay for it yourself, depending on the circumstances. That's up to the hospital. But I think you do get some protection by showing good faith. And good faith means treating that physician like any other physician who's ever had discipline invoked against them, and making sure the bylaws are followed and followed to the letter. All the procedure, communication with the physician regarding the bylaws. You have been the subject of a summary suspension. Here is your remedy, all put out in a letter. And as you said, Todd, very good faith communication with their counsel, who are hopefully knowledgeable about this and do not see a hospital action as they would a medical malpractice or a criminal action, understanding the nuances of this particular action and hospitals and healthcare in general. So all
That's
good
an
points.
excellent point. Excellent point.
Yeah. And I guess, Amanda, that leaves it to you to close us off again. And by the way, thank you for hosting this today.
Absolutely. It has been my pleasure. Thank you all for joining us today. We really hope that you found this discussion insightful and informative. As a reminder, we're going to send out a follow-up email with a link to the recording so you can revisit or share it with any colleagues that you think might find it helpful. If you have any questions or would like to continue this conversation, our contact information is on your screen. So feel free to use that to reach out to us, and we look forward to connecting with you all soon.
All right. Thanks, everyone, my colleagues
Thank
and
you.
everyone else. Best of luck to everybody. And any questions, please reach out. All the information is there. Thank you again for your participation today.
Thank you.